SJC-13247, James B. Carver v. Carol A. Mici and others.
Great. Okay, Attorney Sullivan, Puccini.
May it please the court, Sharon Sullivan Puccini on behalf of James Carver. James Carver is an inmate who has multiple serious medical conditions, including the removal of a brain tumor that later led to his incontinence, vertigo, tremors, leg neuropathy, and ultimately his confinement to a wheelchair. He has a pusher who assists him. He has a catheter, medical briefs, a helper for tasks, and he must be housed in a facility with 24-hour health staff. He has no other crimes committed in the past 38 years, and his only disciplinary report that was referred in the superintendent's recommendation to the commissioner was in 2019 for being out of place, which had been due to issues with his wheelchair. And before that, there had been about a decade before for any disciplinary infractions. He was assessed by the Department of Corrections' own risk assessment and recidivism, and he was found to be low risk for recidivism and violence, and he was classed to a minimum security facility. And as this court found in Buckman, research shows that elderly and infirm prisoners are considered less likely to reoffend when released. He is eligible for medical parole.
But counsel, our question isn't eligibility. The question for us is whether or not there is an abuse of discretion. Isn't that right?
Correct.
Given the January 2020 incident, which I have not yet seen the video of, but as described, why would it be an abuse of discretion for the commissioner to determine that your client still poses a risk to public safety?
Okay, so there's no issue about whether he's permanently incapacitated. Dr. Strauss has already determined that. So what the commissioner was required to do was...
Well, you mean permanent incapacity is defined as not just what the licensed physician determines, but also that it is so debilitating that the prisoner does not pose a public safety risk.
Correct.
Which is why I was focused on the January incident.
Correct, and I'm just going to correct you. It was June 2020 incident.
Okay, so June, even sooner.
But why that's important is because the classification report that was done, that was submitted in this case, happened after that incident. That was June 2020, and then he was classified after that. There's no mention of that incident. And that incident, which you have not seen, my review and obviously is different from what the DOC's review is of that incident, as well as
Either
the district
really
attorney.
is relevant on my abuse of discretion standard.
So abuse of discretion. Deference is not abdication. She does not have unlimited discretion. And you can see that by the numerous different opinions or decisions she's made, and other Superior Court cases have come down with Superior Court judges saying that she has abused her discretion, she's made arbitrary decisions, and we have given you some examples of that in the record. So she has made, so for her abuse of discretion in this case, what is she required to do? She's supposed to get a medical parole plan from the DOC, as well as a written diagnosis from the physician, which she has, and an assessment of the risk of violence. There's no medical parole plan in this case.
Can you not lump the different issues together? Let's try to do them separately. So the first point you made is about the classification plan, right? And the classification plan was to determine what level of security was appropriate for him, right?
Correct.
So that's different than whether he's being released. Whether they manage him in a minimum security versus a high security environment is a different issue than whether he's so debilitated that he doesn't present a public safety risk, right?
Correct, but they also had he also included the 2009 risk assessment done by the DOC that was sent to the commissioner from the superintendent with his package that he gives the DOC. And that shows that he's at low risk of recidivism, low risk
Right,
for
but again,
violence.
that purpose of that was, and I may be confusing the two cases, and if I am, you let me know, but I thought the purpose of that classification was to determine the level of security in a business. Is that wrong or correct?
But the classification report in the record, you'll see that it has numerous indications of his what he is capable of and his medical restrictions. There's all kinds of different things, and at the so with both together, those are show that he is a low risk, and that's actually one of the things that.
And okay, can I get that? Can I shift you to the role of the offense for a second? Because your client was convicted of arson, right?
Correct.
So, and I'm trying to understand the role of the offense because we're so debilitating that he doesn't pose a danger. Don't we have to take into account the offense that he committed?
Correct. You do. You have to consider the offense. So in this case,
Because if he was a bank robber, I understand he's not going to be a bank robber anymore. But arson presents a different set of risks, doesn't it?
it does, but it's not just the offense that it's a risk to the public a public safety risk in general. Also, you can consider the offense. But in his condition, is he able to get to a place, get materials? Would he be able to commit an arson?
Let's look at that. All he needs is matches, right? And and some sort of an accelerant.
And how would he be able to do that? But I have to make the more important point is why the commissioner in this case committed a substantial error of law is that she had no medical parole plan from the DOC. This court has said it's supposed to be a collaborative process.
I agree she dropped the ball on that, but it doesn't make any difference because didn't the client provide a medical plan?
Correct, but that is not a substitute for what the DOC is required to do, and you have said that in both Buckman and Malloy. So she has committed a substantial error of law. So in not having the plan, in not doing a plan, because the plan, an appropriate plan, can reduce the risk to zero. If the plan had included for Mr. Carver to go to someplace, say Mission Hospital, Mission Care, he would be in a facility that there would be no matches. Any nursing home, there would be no matches. He would not be able to, so that risk is zero. He needs to there needs to be an appropriate placement. The people who are, the inmates do not have to be totally incapacitated to the point where they cannot function. Mr. Carver meets the standard for permanent incapacitation. His risk of reoffending is low in his physical state, and as well as if there had been a plan put in place for him, his risk would be at zero. So I'm going to move on to the point that permanent incapacitation does not mean total incapacitation. So the commissioner and the DOC in their brief make a lot of arguments about ADLs and what an inmate can do what can they do? It's not total abstinence of functioning that's required under the statute. It's what they're trying to do with the debilitating condition and keep going back to those ADLs is they're narrowing the class of inmates who would be eligible under the statute, and that is not what the legislature wanted with this statute. So getting to the video, and I understand if you have not watched the video, I do want to make a few points about that. We have provided, the Prisoners Legal Services and CPCS has provided a amicus brief that discusses that in the incident on June 20th, that Mr. Carver was in a apparent psychiatric disability. And we know from your cases and from the ADA that it applies to medical parole and that the commissioner cannot discriminate against Mr. Carver. I would suggest when you watch the video, you can see that it is an obvious overreaction by staff. I will say that he was not given a disciplinary charge for that action. He suffered a wrist injury from the risk of force.
And, counsel, I go back to the standard of review, which is where I started. If I would make a different decision, it doesn't matter. The question is whether or not the commissioner abused her discretion in making this decision.
Well, she has to consider all the factors. And her weighing, in this case, our position is that she did not weigh appropriately. I know that she can give whatever weight she wants, but what she found in the video, she basically takes what the district attorney says and verbatim says this is basically what she saw. And then at the end of her decision, she says, when she goes through the reasons, the last thing is nothing in the video, use of force incidents demonstrates that Mr. Carver is either terminally ill or permanently incapacitated. But our position is that when you see the video, that he does appear to be, he's not as strong and combative as the district attorney makes out in her letter to the commissioner. There's an awkward arm raise, which they call a punch but when you see his condition and the way he's moving in that video, it shows that he is incapacitated. That video, the DOC has argued, is only one point in her, and it's not dispositive of her decision. But again, what's the abuse of discretion? It's the weighing, again, the weighing of the factors, and she has to do a reasonable weighing of factors. And our position is she has not done that. She has not considered an appropriate plan, which this court has said has to be done, and we're here again, and these cases that keep happening over and over again. There's numerous remands. These cases are being dragged out. There's continuous delay. Not just my case and the case that you're going to hear next, but there's numerous cases that just keeps happening. There's a statute that should be followed. The commissioner is not following the statute. She's not following the intent of the legislature.
Do you know, counsel, are there any civil suits pending in any, in the federal jurisdiction or anything collectively for the prisoners on this issue?
Not that I know of. And if there are no other questions, I will rest on my brief.
Okay, thank you.
Okay, Attorney McLean.
Good morning, Your Honors, and may it please the Court. Scott McLean for the respondent appellees, Carol Mici, the Commissioner of the Department of Correction, and Stephen Kennedy, the Superintendent of the Old Colony Correctional Center. Respondent appellees respectfully ask this Court to affirm the lower court's decision to uphold the Commissioner's decision to deny medical parole for the petitioner appellant, James Carver. As the Court properly found, that the commissioner's decision in denying medical parole for Mr. Carver was not arbitrary and capricious. As has already been mentioned by this bench, in order to qualify, for medical parole, a commissioner must find that a prisoner is terminally ill or permanently incapacitated, such that if he were released, he would live and remain at liberty without violating the law, and as released would not be incompatible with the welfare of society. In order to meet this threshold, one must be permanently incapacitated, which, as this bench has just noted in Ms. Sullivan-Pacini's case, that permanent incapacitation is not only a physical or cognitive incapacitation that appears irreversible as is determined by a licensed physician, but that incapacitation is so debilitating that the prisoner does not pose a public safety risk. That second component, that he does not pose a public safety risk, is the purview of the commissioner. As this court recognized in Emma, it is the commissioner who determines whether an individual is eligible for medical parole.
Can I ask you a quick question about your regulation? Because I find the statute clear, but I get a little worried when I read the second part of your regulation, which says requires the prisoner's placement in a facility or home with access to specialized palliative or medical care. Why is that required?
Well, Your Honor, I would say that is required insofar as it indicates the individual suffers. That goes to the first prong, Your Honor, that the individual requires ongoing medical care, and then to make sure that if the individual is released on medical parole, that he would be in an environment appropriate for that care.
If his family is providing, if he's in a wheelchair and he's so weak that he can't commit any crimes, why can't his family be able to take care of him? Why does he have to be in an institution to meet this requirement?
Well, it is not the department's position that he has to be in an institution. Individuals have been released to family situations.
But what is the access? So access to medical care means that the family can get him to a doctor?
Well, for example, in Mr. Carver's case, if you were to be released to his family environment, which was the proposed medical parole plan, their house would have to be outfitted, I imagine, to accommodate that, a wheelchair ramp, the other medical accommodations that would be required.
So that provision doesn't require institutionalization. It just requires the appropriate level of care for the person. Is that right?
Exactly, Your Honor, and that leads me into another point, which is the purpose of the medical parole plan itself. Attorney Sullivan-Pacini said in her argument that the commissioner is required, or that the DOC rather is required to author a medical parole plan, and B, that plan can in turn mitigate the individual's risk, thereby rendering him permanently incapacitated per the statute. I disagree with Ms. Sullivan-Pacini on both counts. Nothing in Buckman or in the statute requires that the DOC author specifically a medical parole plan.
But haven't we said in our two opinions that the DOC has to prepare a plan?
Well, in this case, Your Honor, the medical parole plan was provided, and if I would analogize it to Malloy, Your Honor, where in that case, I believe it was this court stated that there can be a lot of shifting and changing in a medical parole plan from the time that the petition is filed to the time that the inmate, if he is determined to be eligible, is actually released, and that there can be a lot of time, and there's a lot of time in between, and so a lot of factors can change and shift. So a medical parole plan that either even that the petitioner files or is filed on behalf of the petitioner, or even that the superintendent, for that matter, prepares to send up to the commissioner in a case that a plan was not provided in the petition, that might be insufficient by the time you get to the day of release. Beds might not be available. Doctors might change. So if an individual is determined to be permanently incapacitated and is by the commissioner and is determined to be eligible, then yes, the department is required by the statute to make sure that at the day of release, there is a medical parole plan in place. Now, that does not necessarily mean that the DOC needs to author a medical parole plan that goes up to the commissioner specifically with the superintendent's recommendation, especially where, as here, a medical parole plan was provided. Now, if the commissioner determined that Mr. Carver was in fact eligible for release, was in fact permanently incapacitated.
Can I ask a question about what is your understanding of what so as Justice Wetland pointed out, there are two components. You have to be so, you need to be impaired, but you also have to be so impaired you can't, basically commit a crime. But on the first part, I'm a little confused of what the commissioner is requiring now. Is it that are you permanently incapacitated in all functions or just an individual function?
So, Your Honor, it's a fact-intensive case, point-by-point case. This bench made the point earlier that Mr. Carver's crime was arson. Specifically, what was before the commissioner was that he rolled up some, well, it was more than arson. It was arson and murder. He rolled up some newspapers, put them in an...
But I get the second part of this. I'm asking about how the definition under the CMR says, so debilitating it causes a prisoner significant and serious impairment of strength or ability to perform daily life functions such as eating, breathing, toileting, walking. Are any one of those sufficient? Or does it have to? I mean, I'm trying to get a sense of what the commissioner is requiring.
Sure, Your Honor. So, and again, I go back to my previous answer. It's individualized, and that's why I was explaining the circumstances of Mr. Carver's particular crime. He rolled up some newspapers, threw them in a building entranceway, lit a match, burned down a building, 15 people died. So, to this bench's previous point, what physical capacity is required to commit that or a similar crime? And in Mr. Carver's case...
Let me pose the hypothetical. This person's physical conditions are clearly debilitating in numerous ways, right?
Correct, yes, Your Honor.
Now, he can't rob a bank anymore. But is there any issue of whether it's so debilitating that he could rob? I mean, if he were a bank robber, I take it he'd meet the requirements, right?
Well, and again, Your Honor, I also don't necessarily, the individual does not need to commit the exact same crime. In this case, in Mr. Carver's case, the commissioner's position is as strong as it is because he is capable of committing the same or similar crime. But it does not have to be the same crime. It doesn't have to even be a similar crime. It has to be a risk, whether the individual poses a risk to the public.
But we're not looking at every possible crime for every possible petitioner, are we?
No, you're looking at this particular situation. This is whether or not Mr. Carver specifically qualifies for medical parole and whether or not the commissioner's decision to deny that parole was arbitrary and capricious.
Again, I'm just trying to break out the elements. So the crime that the person has committed is a relevant factor, obviously. Are they free to consider other crimes? I think they are, right?
I would agree with that, Your Honor, and the reason I say that is because of the definition of permanent incapacitation. That is so debilitating that the prisoner does not pose a public safety risk. It's a public safety risk. There's no quantum there. The commissioner has to make in her discretion whether an individual, if released, could pose a public safety risk. To go back to Mr. Carver's case, Mr. Carver there's no doubt, there's no contest that he has a number of debilitating conditions. Right. However, what the medical...
Number of serious debilitating conditions. Most crimes, there are a lot of crimes he can't commit anymore, right?
I would certainly... Well, not being an expert in criminal law, but I think, yes, I would say that. So
in this case, because the crime of arson is so easy to commit physically, he meets the requirement that he's a risk. Is that Is that your argument?
Yes, that was the commissioner's ultimate finding, was that there was nothing in the record to show her that in his current physical condition, Mr. Carver could not commit a crime, or the crime that he did commit, or a similar crime. And so insofar as that physical capability, that physical capacity is concerned, that is where an index offense does come into play. So,
But again, if he were a bank robber, they'd be required to let him go, right?
I would say, Your Honor, that again, that's why I want to point out that, though in Mr. Carver's case, the commissioner's decision was so obvious on the record, so to speak, because of the nature of the crime. Even if an individual was a bank robber and he were in Mr. Carver's position, the commissioner could certainly still find, based on the totality of the record.
That's what worries me, is he is so debilitated. There got to be limits if he were, and how we evaluate, because otherwise no one's going to get released for anything, which isn't the purpose of the statute.
I agree with that, Your Honor, and respectfully, that's not the situation. Individuals have been released on medical parole to date. I believe individuals have been released on medical parole. The commissioner has decided, looking at the totality of an individual, again, and to keep going back, harping on this, it is an individualized analysis of the prisoner, who is in front of the commissioner who is petitioning at that time. In Mr. Carver's case, notably, the ADLs he is capable of. Dressing himself, feeding, toileting. He is mobile in his wheelchair. All indicate a certain level, for example, of dexterity that an individual looking at his case would look at and say, yes, an individual like this could, if so inclined, still commit an arson.
He's dexterous enough to be an arsonist, but he's not dexterous enough to commit crimes that require physical force, is he?
Well, Your Honor, I would refer you to the video on that. The commissioner the commissioner said that the video demonstrated that there was certainly nothing in the video to demonstrate that he was not so physically incapacitated as to commit the index offense. It showed a level of physical combativeness. Whether that would rise to the level, for example, of criminal assault and battery, I cannot say. This is a situation where this court is being asked to determine whether the commissioner's decision in a very specific situation with very specific facts was arbitrary and capricious. So I will go back. I will mention, going to the use of force incident, the court also, the lower court properly held that the commissioner's use of that was not arbitrary and capricious. There was some mention of an amicus brief. I will say that perhaps the ADA component was not fully fleshed out in the lower record, but to any extent that this court is considering it, it's not applicable here for two reasons. One, the use of force incident was not a primary factor in the commissioner's decision. As I already mentioned, there is the medical evaluation that was before the commissioner, which showed Mr. Carver's current physical capacity, and in the commissioner's mind, he still had that ability to perform, again, an offense similar to or like the index offense. However, that being said, her consideration of the video was not improper in any event, and of the incident reports for that matter that described it, because the incident reports themselves, as the lower court found after reviewing the video, there was nothing inconsistent between the incident reports that had been written by correctional officers and the video itself. The correctional officers had firsthand experience of the situation, and again, the commissioner did not deny Mr. Carver based on the use of force incident because he was in a mental health episode. It was because of his physical capacity that was demonstrated through the use of force video.
Okay.
And
Yeah,
if no one has any other questions, I would rest on my brief.